Our next case is Sabatine versus Sabatine, a 15-minute mini oral argument on the application. Good morning. You both have 2 minutes of a free fire zone, and you may reserve time if you wish, but we ask that you keep track of that yourself.
All right, thank you.
Begin when you're ready.
Good morning. Ann Argeroff for Appellant Colleen Sabatine. I reserve 5 minutes for rebuttal. The issues involved are the Court of Appeals' determination of the ECE, or Established Custodial Environment of the Child, the clear and convincing evidence standard, and in its remand to the trial court. An established custodial environment is a child-focused determination that must be based on the totality of circumstances by controlling statute, Section 27, subsection 1C of the Child Custody Act. The Court of Appeals materially erred in determining the ECE limited to a remote period of time when the parties lived together during the marriage, quote-unquote, 365 days a year, before the separation in September 2020, and did not consider the period post-separation, including the divorce litigation and the appeal periods, which is now 3 years. Under the statute, the ECE is based on the totality of the circumstances. It is child-focused. The statute provides the custodial environment of a child is established if over an appreciable time the child naturally looks to the custodian in that environment for guidance, discipline, and necessities of life and parental comfort. Other express statutory considerations are the age of the children or child and the physical environment itself. Here the children were 2 and 4 at the time of separation. They are now 8 and almost 6, and they were very young when the separation occurred, and they're very different developmental stages now. As for the remand, the Court of Appeals materially erred in remanding specifically to apply clear and convincing evidence to appellant's request to continue an established environment that had existed with her prior to the separation as the day-at-home parent, and has continued since the separation in September 2020. In the remand, there was no mention of Fletcher or Butters, no instruction concerning up-to-date information consistent with the statutory totality of circumstances and required by law. The remand removes trial court discretion and trial court fact-finding in determining an ECE and the corresponding evidentiary standard, and it's essentially the same instruction that was vacated in Butters, which was to apply the clear and convincing evidentiary standard to the best interest factors without regard to any changed circumstance that might have occurred during the pendency of that appeal. Here it's been over 3 years since separation, including the time pending, or the time during the divorce proceeding and the time pending on appeal.
Ms. Argeroff, can you help me? I just want to try and understand this a bit. So the divorce, the complaint was filed, I get first in Genesee, then Leelanau, and then it got brought to Leelanau. There's a temporary order entered in January of 2021, right? Correct. And that temporary order, which is not unique. I mean, I think these happen. Sometimes parties stip to them. Sometimes yes. They go to the referee, friend of the court, right? You get this is going to take a while. We need a temporary order of how we're going to operate in the meantime, yes. Right? And in that case, the father had 69 nights in the temporary order.
Correct.
Overnights. And then in June of 21, his overnights was increased to 117.
That was after the 7-day evidentiary hearing that had been referred to the friend of the court. Yes, and so okay. After that, the friend of the court referee issued his recommendation, making all the findings, and increased father's time, yes.
To 117.
Yes.
So then in November of 2021 is the judgment of divorce that's entered. That was
the de novo, November of 2021 was the de novo opinion. Father objected to the referee opinion based on financial issues. Brief de novo hearing was held in October, and then the de novo, the trial court's decision after de novo hearing was issued. But there was no new evidence concerning the custody or parenting time. And
so he was still at 117.
Still at 117.
Okay.
Then the judgment was entered in late March. I believe, I don't remember if it was March 21st or 29th of 2022.
Okay. So when you're looking at the established custodial environment at the time that the trial court is making this decision, and whether or not the challenge to custody and parenting time is going to change that ECE. Here, the Court of Appeals said, well, when we're looking at this order that we're looking at, we should go back to pre-separation, right? And both parents had 365, and so 117 is a significant change from 365. I'm simplifying, obviously. But there is this temporary order, right, of 69 nights first and then 117. And so when the court is looking at the change and whether or not that alters the ECE, why shouldn't the court, and I think the trial court did properly look at what was that with the parties were operating under these temporary orders. And so, but the Court of Appeals, I'm wondering if you read this the same way I do, they're in like one sentence, they say the custody award in this case was a new order because the January temporary order was issued without an evidentiary hearing, and they cite Thompson versus Thompson. And so I read that as them just sort of ignoring the temporary order, which justified them looking at pre-separation, right? And Thompson versus Thompson, which I didn't see it really in the briefing, but my understanding of Thompson versus Thompson is that, you have a temporary order issued, and then on appeal, one of the parties, I forget which one it was, said you don't get to challenge custody because you agreed to this temporary order. And that's obviously not right. That doesn't mean that temporary order doesn't have force and effect or isn't relevant to both the determination of ECE and whether there's a change.
Correct.
Is that correct?
Yes, and I think the trial court made the correct decision based on the reality for the children. And there's cases, and we discussed this, Blazkowski and other cases, that no matter how that ECE is created by order or no order or not adhering to an order, which happens frequently in family law, where parties do things with, that's different than what an order is. What is created is still an established custodial environment because it's a child-focused determination. And actually this court, I believe in Daly v. Ward, and maybe in O'Brien also, recognizes that, and I'm not saying there was error. At that time of that temporary order, father filed numerous, that was at the end of January, father filed objections and also numerous orders. Everything was immediately then referred to the friend of the court for hearing. And but even if there was error, and I'm not saying that there is, but even if there were, Daly recognizes that error, we can recognize that error and things should be addressed immediately, but father never appealed that temporary order either. He could have filed an interlocutory appeal. He did not. But what Daly says is that we recognize that there can be injustices done to the adults. There can be things that hurt a parent, and that happens so frequently in our cases. But the focus still is, what is the established custodial environment of the children?
Oh, sorry. Go ahead.
We shouldn't set up a system, though, that incentivizes taking children without consent. So if one parent takes a child to another part of the state without the other's permission, and the custody dispute ultimately unfolds and a temporary order is entered without a hearing, does that not create an incentive to move children prior to the dispute to a state so that you now got the roots for a new custodial environment, even if you don't have the consent of the other parent?
We don't see that often where there's an actual intent, hey, I'm going to remove this child. In this case...
But if we follow the rule you want, I think we're creating that incentive.
I'm not saying that that's the rule we want to follow. I'm saying there was a hearing that came immediately after the referee hearing started, within just a period of time. If there had been a remand back, the referee hearing would have started within that period of time too. But we also have to look at the practicalities here too. This case involved the parties living in different areas of Michigan. The children were with mother. The mother had an established custodial environment prior to the separation. Even in intact families, there are differences in how parents are involved based on practicalities, based on is someone working outside the home, is someone not. Those are practicalities that are addressed, and there is an at-home parent. Mother was that, appellant was that when the parties were together. She left the family. They had marital problems. There's discussion in the facts about marital counseling, about concerns about safety. The mother made a decision to leave before any case was filed. There was no requirement to get any kind of order. There was no attempt there was an attempt to address a situation that was not tenable in the home. But since then, the parties have accommodated, they're working together. But what I was going to say is that we're not advocating to create a situation that incentivizes any type of behavior. What we're saying is that even if father had appealed that temporary order, which he did not do, it would have gone up to the court, it would have been remanded, and an evidentiary hearing would have started. But the children there had to be a decision made, and the decision was made to keep the children where they had been. And that it makes both practical sense, and it was addressed quickly in the evidentiary hearing.
Can I ask you, if say we agree, what if we decide that the trial court, in fact, got it correct on the ECE, applied the proper standard in determining that the order, the final judgment didn't, by a preponderance of the evidence, change established custodial environment, do we need to remand? I mean, or is it just reverse the Court of Appeals and reinstate the judgment of the trial court? It's sort of, these cases are never really done, right?
They're not done. Custody and parenting time are always modifiable. They can always be changed.
Because there's been a period of time from when this was appealed till now, or till whenever we decide the issue, right? So
Right.
I don't know, and it's not part of
That's
the
what I
record, are they operating
Right.
under the agreement that's
Yes,
being
yes,
appealed? Okay.
Yes. That's consistent. The kids are in school. They are operating under the agreement. This brings up 2 points that I wanted to raise. First, plaintiff argues bond with the children and the father throughout her briefing. Yes, there's a bond. There's a bond between parents, and there's love between parents. But bonding is not synonymous with an established custodial environment, which is determined from the child's perspective, focuses on a steady, continuous day-to-day circumstances, where a child looks to in that physical environment for continuity and for decision-making and for the necessities of life, driving to school, doing homework, preparing meals, getting kids ready for bed. But it doesn't mean that children aren't bonded. My mother was the at-home mother. She was my established custodial environment in terms of my day-to-day life. Doesn't mean I didn't bond with my father. It doesn't mean I didn't love and don't love my father, who is no longer here. The love is there, but bonding is not the established custodial environment. The children are where they are. They're living their day-to-day lives, and that's what their established custodial environment is.
Didn't the trial court found an ECE in both parents?
It did, and
Okay.
you know what? And I discussed that in my brief, and that's sometimes family law cases are messy. How things are labeled can be messy. I think the trial court did a detailed job talking about what had happened in this family. I think it was trying to be empathetic, and it found that there was a joint established custodial environment, but that doesn't mean 50-50. That means what the children are experiencing now. Their joint environment was weighted to their time with their mother, 240 or more days a year with mom during the school year, and seeing their father, their custodial time with their father. I argued in the brief that it's a custodial environment, whether we call it joint, weighted with appellant, or we call it an established custodial environment with appellant only. They're both the same thing, because what is the reality for the children is the reality for the children. And they are living their lives with their school life, their.
You're going to leave yourself with no rebuttal time.
Oh, pardon me.
You're going to leave yourself with no rebuttal time.
Okay, yes. I reserve any time for, if I have any left, for rebuttal. Thank you.
Good morning, Your Honors. Jordan Ehlers on behalf of the appellee father, Andrew Sabatine, in this matter. Throughout this matter, appellant mother has taken several positions that are simply inconsistent with established law and the facts of this case. This matter has ended in front of this court on the question of the children's established custodial environment and the Court of Appeals rulings related to that environment. Contrary to appellant mother's arguments, the Court of Appeals in this case has not substituted its judgment for that of the trial court on the question of the children's established custodial environment because the Court of Appeals and the trial court came to the same conclusion. That is, that the children have an established custodial environment with both parents. The Court of Appeals' opinion in that regard is consistent with longstanding case law of the Court of Appeals and this court. Additionally, the Court of Appeals' correction of the trial court's error in applying the incorrect burden of proof, which was to remand for the application of the clear and convincing evidence standard, is also consistent with the case law of this court and the Court of Appeals. Because the Court of Appeals complied with the applicable law as established by this court and the Court of Appeals precedent and made a decision that is consistent with the facts of this case, this court should affirm the Court of Appeals' opinion. I would waive the remainder of my fire-free zone. Before I get into what I've prepared for today, I wanted to start with your point, Justice Zara, which is, the creation of this incentive to take children before an order has been entered. Contrary to Sister Counsel's comment, I do actually see this quite often, where you have one parent, whether they remove the child, across town or they remove the child across the state. There is some removal of the child from the marital home at some point. And the issue is that the way that the law is written currently is that there is no disincentive in the law for that kind of behavior. There isn't a fix. The closest thing that there is the application of the clear and convincing evidence burden. Now, there should be a disincentive. We should not be incentivizing parents taking children before orders are entered or without consent of the other parent. However, given the way that the Child Custody Act is written, I think that this incentive is going to have to come from the legislature at this point, unfortunately.
So, can I ask you, so I understand your point, there is no statutory disincentive, but there are avenues for relief that your client filed a motion to have the kids move back to within 100 miles. There were motions surrounding the entry of the temporary order, right? All of which could have been judicially reviewed through appeal.
Correct.
And were not. So, and at that time, you had 2 months of this situation, right? Where they went from Traverse City to wherever they went to, I'm sorry, I'm blanking on that. Fenton. So that's a very different scenario than years later from the perspective of the kids. I don't think you disagree that the statute is written from the perspective of the children, right? So that window at the time, even if there isn't a disincentive for mom to have done what she did, there is an avenue for dad to have sought relief from what she did.
I would agree, Your Honor, that there were avenues. However, I think if we look at the practical reality, so my client did file his motions to have the children return to Traverse City. The trial court routinely ruled that while the trial court believed that mother should not have done what she did, the trial court did not think that it had the authority to order her to come back. Now, my client was not aware that he could have appealed that to the Court of Appeals at the time. He was obviously more concerned with just getting any sort of parenting time with his children at the time because mother had been very controlling of parenting time. She was requiring father to drive to Fenton to see his children at all. She was restrictive on phone contact. It was very, very difficult in those initial months for my client to have any sort of meaningful contact with the children due to mother's limitations on that contact. Now, the practical issues with taking an order like that up on appeal is that, as Sister Counsel said, the remedy is to remand for an evidentiary hearing, but the trial court isn't going to move the children during that time.
Well, but following an evidentiary hearing, if you establish that 69 days isn't sufficient, I mean, that to me is the most logical time when you're looking at 69 days compared to pre-separation, right? I mean, I think I struggle with the fact, and the family law section does not support your position, right? But of saying that in every case of a divorce, you're going to have a change from 365 days for both parents. Even 50-50 is a significant change, right? So going 3 years down the line and looking at going back to pre-separation can't be the right way to look at it, I don't think. But maybe 2 months out, when you're saying, look at, like, 69 days or this temporary order or any change of that is a huge change from 365.
And I don't necessarily disagree with you, Your Honor. I think the point that I'm trying to make is that even if my client were to appeal that order and be remanded for an evidentiary hearing, it would not be within that 69-day window. We would be well beyond that. I mean, I think the evidentiary hearing in this case took 7 full hearing days. That was a very long period of time where it could have been 8 months by the time we got an order from the trial court. You know, assuming that my client had appealed it on an emergency basis, the Court of Appeals grants that emergency relief. It gets remanded to the trial court. They have to wait the 42 days before the trial court can begin anything unless the Court of Appeals gives it immediate effect, which is rare. And then we have to go through the whole evidentiary hearing process, and that's still all that time that's being counted where the children are still infant with mother. And I just think the practical realities are, I'm not saying that my client shouldn't have appealed it. I mean, obviously, he wasn't aware that he could have, but the practical reality is that because there is no disincentive for what mother did at the beginning of this, there's no way to fix it down the line.
Well, there's no disincentive because a parent has a right to parent their child, right? Your client did as well as hers. So I don't know that a statute can say preemptively when you're married and you have full custody and the right to control your children that you can't move somewhere before filing divorce.
I don't think that's what I'm saying a statute should say. I mean, obviously, I'm not a legislator. I'm not trying to create this new kind of law. What I'm saying is that in this case, the pre-separation environment was still relevant. The weight that relevance is going to be different in every case, and I believe I explained that in my supplemental brief. I think, for the most part, I think the basic premise that myself, Sister Counsel, and the family law section all agree on is that this is child-centered, and it's going to be different in every case. Every case is going to be different.
Is it child-centered, what you're asking, if we're now looking back 3 years? I mean, I'm recognizing all the arguments about the unfairness that your client feels that happened in this case, understanding all of that. But looking at today, if a court were to have to look at this today, what's the child-centered approach?
I think the child-centered approach is to, assess where the children are at. We always have to do that. And I think that part of the issue with the appellant's argument about the remand instructions that, well, the remand essentially takes away the trial court's ability to fact find. Well, that's not true. There's nothing in the Court of Appeals opinion that says the trial court should not consider up-to-date evidence. There is nothing in the Court of Appeals opinion that says, mother can't file a brief that says, here are the mandates from Fletcher's and Butters, trial court, follow them. And there's nothing in the Court of Appeals opinion that preempts the trial court, the presumption that the trial court knows the applicable law and will apply it. Now, I do see regularly an issue where trial courts are not necessarily applying the law consistently. However, there is an intermediary Court of Appeals, and mother has the ability to correct that on the remand. I think that if we're looking at this from the perspective of the children, the Court of Appeals finding in affirming the trial court's decision on the ECE, albeit in a different way, was the right result for the wrong reason. And I think that it doesn't require action from this court, mainly because this opinion was unpublished, but also because what the Court of Appeals has done overall is consistent with the law.
What do we do? I mean, Justice Kavanaugh talked about this. I mean, every separation or divorce involves probably a significant diminishment in parenting time unless one parent is pretty much out of the picture. So, I mean, that's like the norm in just about every separation agreement or where they're, they work out temporary, even if it's temporary, that's pretty much the norm. How does that, I mean, I'm struggling, and I know the family law section talked a lot about this. I'm struggling with that aspect of this.
Yes, Your Honor. And I think that the facts of this case are rather extreme, right? We don't regularly have cases where, one parent is essentially 4 hours away from the other parent. Usually it's the parents separate and they are able to work out, a schedule that allows the children to have more frequent contact with the other parent, right? So if you have a parent who is, for instance, moved 20 minutes away, that's much different than putting the children in the car for 10,000 miles a year, as it's the case in this case. I think that what the Court of Appeals has done here is not anything that is different than has happened in other cases. And I know that this court in its questions, brought up the Bofaisal case, which had similar facts to this case. And this court, when it had the opportunity to review Bofaisal, chose not to, whether that had anything to do with, the makeup of the court or whatever it was at the time. Bofaisal essentially says that, what is important is from the child's perspective. And from that child's perspective, the established custodial environment has always been with both parents. And that's how it was in this case as well. And that's what the trial court found, and that's what the Court of Appeals found. Now, today was actually the first time that I've heard from the appellant what her stance on father's established custodial environment is, because in her supplemental brief, she created this very interesting argument about the weight of the established custodial environment. Well, that's not what the law says. The law questions whether an environment exists or not. It doesn't question whose environment is superior. It doesn't question, as sister counsel said, whether it was created by a court order in violation of a court order, etc. I think if this court were to take up appellant mother's reading of the law regarding an established custodial environment, it would create this issue where if a parent did not have 50% or more of the parenting time, that parent's parenting time and their established custodial environment with the children could be disrupted for the preponderance of the evidence because the environment is not, quote, weighted in their favor. And that's not what the law says. I mean, this court, in its questions, cited, and I always say this case name wrong, I say it Purian, I think it's Purin, which is the correct way to pronounce it. And Purin essentially just asks, does this order modify the established custodial environment? It's our position that the judgment of divorce in this case did modify the environment because it's going to affect father's relationship with the children moving forward. Sister counsel in her argument mentioned, doing homework with the children, transporting them to school, things like that. Things that previously my client didn't necessarily have to worry about because of the age of the children. However, as the children get older, these are all concerns that are going to negatively affect my client's relationship with his children because he just doesn't have the opportunity to take part in those things.
When you say it's going to change it, from what point are you basing that on?
So I'm basing that from the entry of the judgment of divorce, when the children were not yet school aged. I think that moving forward, when the children do become school age, when they,
But moving forward isn't the case that we have in front of us, right? Like if there is a change subsequent to what we're looking at the judgment of divorce and whether that was a change from what, right? The Court of Appeals says, let's go back pre-separation, there's an intermediate order. But going forward, I mean, and that's sort of what I reference that these cases are never really done, right? There could be circumstances that change, such as the kids get older, such as, I don't know, any number of things, right? That may necessitate, or the child judge might say that necessitate a change in custody, and then we're looking at the established custodial environment at that time, right? I think you agree with that. You're saying, look, the Court of Appeals doesn't preclude the court from looking at that. That's maybe a matter of disagreement. People can read the Court of Appeals opinion the way they do. But going forward is a different issue than what we're having to decide, right?
Yes and no.
Okay.
I think that when we're looking at whether or not the judgment of divorce modifies the established custodial environment with father, I think that in child custody determinations, there's always a bit of speculation about, if we look at, I was looking in preparation for my argument, this court's, comment in Ireland v. Smith about MCL 722.23E, which concerns, quote, a child's prospects for a stable family environment. That is forward-looking. So there are forward-looking aspects of the child custody analysis that we do have to take into consideration when we're, deciding something on the child's best interests. I see that I'm about to run out of time, so
I've got one,
Of course.
one or maybe two questions. Are you asking us to look at the statute and read into it some sort of public policy position that we look at the established custodial environment at the time of separation, and that kind of locks in at that point in time, and then everything that follows has to be based off of that period of time and not up-to-date circumstances?
I'm not asking that, Your Honor. Our argument is that, the pre-separation environment is always going to be relevant in an initial custody determination, simply because that's where, the established custodial environment gets its roots, right? That's where the parental responsibilities are determined is, the pre-separation environment. The relevance of that environment is going to differ in every case, and I'm not asking for any sort of bright line rule or public policy because it's not possible to do those in family law cases because each case is so different.
Okay, so you're asking us in this case to go back in time for your client and say that there was an established custodial environment and that regardless of what the percentage was, that is what we need to go back to and not look at the change in circumstances of kids living with mom for a period of time during the divorce. Is that accurate?
It's slightly inaccurate.
Okay.
I do think the pre-separation environment here is important. However, what I'm asking this court to do is affirm the Court of Appeals finding the conclusion that the children have an established custodial environment with both parents, which is what the trial court found at the time of the trial court's November 2021 opinion.
Which was at what point in the proceeding?
So the November 2021 opinion, as Sister Counsel kind of summarized the procedural history, that occurred after the referee hearing on the question of custody, which occurred after the entry of the temporary order in January of 2021. The separation occurred at the beginning of October of 2020, roughly. So at that point, the children had been in Fenton for, I believe, a year when the trial court entered its opinion on after de novo review. That's the finding that the Court of Appeals affirmed, albeit by looking at the pre-separation environment. What I'm asking this court to do is deny mother relief, essentially, affirm the Court of Appeals opinion, but not because what the Court of Appeals did was necessarily correct, but because even if it wasn't correct, they got the right result for the wrong reason.
And so what is the right reason?
The right result is that the children have an established custodial environment with both parents. That continued even after separation because of father's efforts to remain involved with the children.
Okay, thank you.
Thank you, Your Honors.
Very briefly, father was represented by counsel at the time of the temporary order. There was a hearing held, and he didn't prove, at least pursuant to the referee recommendations and findings, that he should have custody, primary custody, after the 7-day hearing. We have an issue here, too, as in many cases. What does a parent do when they're concerned about safety of their children? They make the decisions that they think are appropriate. And Factor J has been amended recently to recognize that there shouldn't be punitive action against a parent who acts to protect a child or themselves when they're concerned about safety during a marriage. In terms of, sometimes things are inartfully written or inartfully described, but our position was that mom has the established custodial environment. She had it pre marriage, or excuse me, pre-separation, where both parties did, but she was also the day-to-day parent, and that continued. And that the preponderance of the evidence standard applied to her request to continue that, including after the change at the time of separation, is appropriate.
Thank you. Your time is up.
Okay,
Yeah,
all right. And also Lieberman v. Orr discusses different types of established custodial environments that are weighted in different ways.
Thank you. The case will be submitted.